Good day, I'm here with Dr. Pelayo Moller. We're here to analyze the most recent constitutional amendment that affects retirement benefits in Mexico.
Hi, Rocio. It's a real pleasure to be here with you today. Regarding your question, on April 10th, 2026, a constitutional amendment was published modifying the retirement benefits of thousands of retired workers from state-owned companies in Mexico. These individuals worked for 30 years for the state and had acquired vested rights to their pensions. However, they will be affected because their pensions will be reduced. The amendment established that pension payments may not exceed 50% of the president's salary.
Doctor, have you identified in this constitutional amendment violations to human rights?
Several human rights are affected by the publication and enforcement of this constitutional amendment. The primary right affected is the right to a pension, which the Inter-American Court of Human Rights has recognized as an autonomous right. It is also necessary to consider the particular circumstances of the individuals affected by these reductions. Some of them suffer from health conditions, others will face impacts on their housing, and others have economic dependents who will be adversely affected. Accordingly, this measure affects not just a single right, but multiple rights protected under the Mexican Constitution and international human rights treaties.
Dr. Pelayo, what is the strategy, the legal strategy that you pretend to follow and why?
We will be pursue a dual strategy. On one hand, we will seek to exhaust domestic remedies, specifically the writ of Amparo, which is the principal legal mechanism for the protection of human rights in Mexico. We recognize that our chances of success are limited, given the constitutional and statutory restrictions that constrain the remedy. Nevertheless, this is not our only course of action. We are also considering bringing the case before the international human rights bodies, such as the Inter-American Commission on Human Rights. In these forums, we believe we have a stronger likelihood of success, given the extensive body of case law supporting our clients' claims. At the international level, also, there are precedents that afford broader protection to the right to a pension and to vested rights more generally. The disadvantage of pursuing relief before international human rights bodies is that the process may take years. Nevertheless, for the victims affected by this constitutional amendment, it represents their only real opportunity to obtain justice. Accordingly, we are advising those impacted by this measure that if they wish to seek redress, we can assist them in bringing their claims before domestic authorities and then at the international human rights bodies.
Doctor, what are the possibilities of winning this battle?
Our chances of prevailing domestically through the writ of Amparo are candidly minimal. It is essentially a last resort effort, given the numerous constitutional and statutory restrictions that limit the scope of Amparo in matters of this kind. Nevertheless, we must attempt to exhaust this remedy, as an adverse decision from federal judges and tribunals will strengthen our position at the international level. If domestic courts confirm the absence of an effective remedy, this will constitute a clear violation of human rights that can be readily established before international bodies.
Doctor, why are you interested in communicating to the international legal community this information?
It is essential to communicate and explain the situation at the international level from the perspective of comparative constitutional law and international human rights law. In Mexico, the Constitution is frequently amended, yet there is no effective judicial remedy to challenge the substance of those amendments. This raises serious human rights concerns. It is therefore an issue that should be addressed internationally, not only as a matter of Mexican constitutional law, but also within the framework of comparative constitutional law and international human rights law. Moreover, this problem extends beyond the present amendment, as similar concerns have arisen in connection with prior reforms, including the significant changes to the judicial branch in Mexico of last year.
Thank you very much, Dr. Carlos Pelayo Moller, for this interview, and thank you to everyone. See you soon.